Well, hi everyone. I'm Angela Daly from QUT Faculty of Law. As a lawyer, I don't have a presentation because lawyers are boring and like to drone on instead. So I'm going to drone on a bit, although not very long. So I wanted to talk a bit about the legality of the war on maths, or of the government's stated aim, although pretty vague, as former Senator Ludlam kind of mentioned. They seem to want to be introducing some kind of encryption backdoors into certain services, although it's not entirely clear what they want to do. But if that is what they want to do, then I just want to kind of give an overview of the extent to which that is actually legal or not. And firstly, I want to look at kind of three levels of legality. So under Australian law, under the law of comparative countries, and under international law. And rest assured, this is not going to be very long, so it's not a law lecture as such. Firstly, under Australian law, is it legal to introduce encryption backdoors? Well, I'm sad to say that, unfortunately, the war on maths, even if it's ill-advised, even if maths will win, as Senator Ludlam said, well, we also know the law is an ass. So the war on maths probably is actually legal under Australian law. And this is really because the Australian Constitution has very limited protection of rights. So there are a couple of rights that have protection under the Constitution, but it's very minimalist. And privacy is not one of those rights. We do have a very kind of weird implied right to freedom of political communication. But to what extent encryption backdoors could be challenged against that, I think, is very unclear. So encryption backdoors may interfere with things like privacy and freedom of expression, but to what extent a kind of court would find that to be the case, I think, is very unclear. And particularly if it was in a scenario in which the government was kind of mounting sort of national security or terrorism arguments. Now, I'm certainly no expert on the Australian Constitution, as my accent probably suggests. However, I believe that the current High Court is is not a very sort of activist court, and so it would probably have to take an activist stance if it was to find that encryption backdoors were in violation of the few constitutional rights that we have. Secondly, what's the scenario in some comparative countries, so particularly kind of the US and Europe, or the European Union. So in the US, I mean, the war on maths is a bit of a throwback to the crypto wars of the 1990s that some of you may be old enough to remember going on in the US, which were really around to what extent restrictions on the kind of dissemination and use of encryption 20 years ago were in accordance with the US Constitution, and particularly the First Amendment rights to freedom of expression. In the course of those kind of legal crypto wars, the US Supreme Court did actually find that there was some protection of the right to use encryption, which came from the First Amendment. But it's unclear, I think, still whether, if the US government wanted to introduce something similar, the extent to which that would be constitutional. And particularly, again, in the context where there are a lot of kind of well, I wouldn't say strong, but there are a lot of arguments made around kind of the necessity for national security, and particularly in this scenario with the Trump administration. And we've seen, for instance, with things like the Muslim ban, that some courts have actually upheld parts of that. So to what extent the Supreme Court might uphold a ban on encryption backdoors remains to be seen. But it is true that in the US there are stronger protections as a result of the Constitution and the rights culture that former Senator Ludlam was mentioning. That doesn't exist in Australia, but it does exist in the US. And there's a similar kind of scenario in Europe as well. There's more protection of rights there. There is the European Convention on Human Rights, and there's also the EU Charter of Fundamental Rights, and both of which contain rights to privacy and free expression. And both of these have actually been used fairly successfully in the last since the Snowden revelations, to try and rein in some of the kind of bad activities of governments, particularly the British government, but also the activities of some large internet companies as well. So you might be familiar with, for instance, cases such as the one where the Court of Justice, you might be familiar if you're a lawyer, but anyway, when the Court of Justice of the EU struck down data retention laws in the EU, which are very similar to the ones that we have in Australia. Why were they able to do that? Because there are enforceable rights to privacy in the European Union. We don't have that in Australia. We have a really I would say, pathetic Privacy Act, which is nothing, and similar acts at state level. Sorry, Privacy Commissioner, but it's not actually your fault. Yeah, I know you want to change it. Anyway, but legislation is not the same as having strong constitutional or enforceable human rights, and that has been a massive difference in Europe compared to here in Australia. Laws that would be illegitimate or invalid in the European Union are valid in Australia, which for me is like very concerning. But again, in this kind of similar scenario with encryption backdoors, it's not entirely clear how that would be dealt with in Europe. Some of the cases that we've had so far since Snowden suggests that the courts are actually fairly activist, particularly at the European level. But again, I mean, in Europe, there have been some really bad terrorist acts in the last few years in some countries, I guess particularly France, which currently has an indefinite state of emergency at the moment, which is kind of concerning from a civil liberties perspective, but also is a country which has experienced a lot of actual terrorism, which is not the case in Australia. So in that context, for me, it's kind of unclear how a court might decide on this. Okay, thirdly, third aspect of legality is under international law. So a couple of years ago, the UN Special Rapporteur on Freedom of Expression, David Key, recognized the importance of encryption and actually anonymity or anonymity online for the exercise of the right to privacy and free expression, which are recognized also as rights under international human rights law, including in some instruments that Australia is actually party to. So Australia actually has international human rights obligations around privacy and freedom of expression. They just aren't enforceable in Australian law. And it's, again, encryption backdoors might infringe these protections, not entirely clear, but even if they do, there's not a very strong enforcement process of international human rights law, which is an ongoing issue predating even technology. You can make complaints to the Human Rights Council, which can issue a decision, but the enforcement mechanisms for that decision are not very good. Okay, so despite the fact I've kind of painted a somewhat kind of depressing picture of the fact the war on maths is probably legal, I wanted to kind of put forward sort of 3 avenues that I think we should consider that are somewhat legalistic, and then also 2 practical steps that I think we can take immediately. So the first kind of avenue to consider is that, again, something that we were discussing at lunch, rather bizarrely, and for reasons I cannot fathom, Australia has a bid to have a seat on the UN Human Rights Council, despite the fact it wants to wage war against mathematics, despite the fact there are also kind of human rights infringements in the offshore detention camps, and probably also with regards to Indigenous rights in Australia. But anyway, Australia wants to have a seat on the UN Human Rights Council and was also talking a lot about its great respect for human rights, particularly in the cyber, in DFAT's cyber strategy, which was released yesterday. So I do think that while it might be difficult to kind of enforce rights in legal terms against Australia, I do think that kind of like some negative coverage of these activities in international and national media might actually kind of go some way to derailing this bid and embarrassing the Australian government internationally. But on the other hand, the Australian government doesn't seem to care about the embarrassment around some of its other human rights violations, particularly in Manus and Nauru. So why would it care about the war on maths? And particularly when it has allies in places like the UK also kind of wants to get rid of their human rights obligations and also wanting to wage war on maths as well. Although, as Amber Rudd said, I think yesterday or the day before, she admitted that she has no knowledge really about what the war on maths even is, but she knows she wants it. She knows maths is bad. Okay, so that's like one thing that I think we can consider as embarrassing the Australian government more internationally, particularly when it has, for me, quite a counterintuitive bid for a seat on the UN Human Rights Council. Secondly, I do think we need more strategic litigation, and I think this is something that we can learn from the environmental movement as well. So while there has been a lot of direct action, there's also the environmental movement has also been engaging in strategic litigation. And although I've kind of given quite a negative picture of the lack of rights protection in Australia, I do think we could probably use the few rights that we do have under the Constitution better and could probably mount some kind of creative arguments that would around them when it comes to things like Five Eyes, data retention, and potentially also the war on maths that could actually force the Australian government to defend itself in court, to engage in litigation, which is expensive, in case anyone doesn't know that. Lawyers are expensive, and also draw out some of these things as well. And I think that we could be doing more of that. We haven't, as I'm in the kind of digital digital rights space in Australia, we haven't really been good at doing that, and I think we could do more. Thirdly, I mean, not a super legalistic argument, but I think the Australian government does care about things like innovation, business, and the cyber. So I think we need to make arguments around... Well, I mean, it talks about the cyber. Anyway, I just released a big document about cyber stuff. Anyway, so I'm very obsessed with cybersecurity as well at the moment. So I think we can make sort of arguments around these sorts of terms about how things like encryption backdoors may be detrimental. And it could also entail that some businesses do not operate in Australia anymore or don't conduct research and development work and so on. So if the rights is not kind of getting us anywhere, I think some of these other topics could actually be more persuasive, particularly perhaps to the government. And I think we can also point to a scenario or an example of where Australian government sort of regulation and laws have actually encouraged or kind of discouraged innovation. So I was thinking today about 2014 when Bitcoin startup CoinJar moved to the UK from Australia because Australia introduced laws which would have charged GST on Bitcoin rather than treating it as a currency. So, okay, maybe not quite on the same level of seriousness as encryption backdoors, but that is a concrete example of a company that has left Australia. And so if the government is interested in encouraging innovation and startups and all the rest of it, it has discouraged that with some previous laws. And so I think that could be a more kind of forceful argument. Very, very practically, I had kind of two things to say about really practical steps that we can take. And I think firstly, we need to be much better about lobbying politicians. So obviously writing to your local member and all the rest of it, but also lobbying politicians in Canberra who seem to live in a sort of bubble to some extent where they do not necessarily kind of engage so much with industry, even though they talk a lot about it, or kind of civil society, etc. So I think that we could be doing that much better, and we could actually be explaining to people what even encryption is and why encryption backdoors would be a bad thing. I mean, talking about anyone who's using online banking or even not using anyone who has a bank account has an interest in strong encryption, and I think that is something that politicians who are maybe not so technically literate could easily understand. Second thing is that, excuse me, I think we need bigger and better campaigns. So as former Senator Ludlam was mentioning, there has been campaigns around some other big digital rights issues, but they've maybe been a bit haphazard or not very well coordinated. Even if they have kind of had some successes, think about how much better those campaigns could be if they were better coordinated and also kind of reaching out to the general public more generally. And I actually want to say one third thing, which is that I think some of the I think that could be very effective having media campaigns right now, because I think there is more of a sense of concern around issues such as privacy and data in this last year. So things like the census fail, things like robo-debt, I think have really made these kind of quite mainstream issues. And even around the recent sort of media I've seen around things like the facial recognition capacities that the government has or wants more of, seems to me, I mean, in a non-sort of academic sense or a non-well-researched sense, I haven't done a discourse analysis. It seems more, academics will get that joke, or social science academics will get that joke. Anyway, it seems more critical than I think some of the media maybe a few years ago. So I do think that there is this kind of sense, people are kind of concerned now, whereas before I think things like privacy and digital rights were a much more kind of niche, weird sort of techie issue, whereas I think now they're kind of a mainstream issue. Therefore, I think we do need more lobbying and we do need better campaigns. But on that point, I can't kind of direct you to a particular campaign or organization just yet, but I can say that if this war on maths ramps up, then I think we will see a big campaign about it. So I would say kind of watch this space, maybe kind of if you don't already follow some of the civil society organizations in Australia, if you follow them, and you will find out about the big campaign if and when it's necessary. Okay, thanks very much.